Michigan Constitution of 1963, Article 6, Section 1. Except to the extent limited or abrogated by Article 4, Section 6, or Article 5, Section 2, the judicial power of the state is vested exclusively in one court of justice, which shall be divided into one Supreme Court, one Court of Appeals, one trial court of general jurisdiction, known as the Circuit Court, one probate court, and courts of limited jurisdiction that the legislature may establish by a 2/3 vote of the members elected to and serving in each house. Section 2. The Supreme Court shall consist of 7 justices, elected at nonpartisan elections as provided by law. The term of office shall be 8 years, and not more than 2 terms of office shall expire at the same time. Nominations for justices of the Supreme Court shall be in the manner prescribed by law. Any incumbent justice whose term is to expire may become a candidate for re-election by filing an affidavit of candidacy in the form and manner prescribed by law, not less than 180 days prior to the expiration of his term. Section 3. One justice of the Supreme Court shall be selected by the court as its Chief Justice, as provided by rules of the court. He shall perform duties required by the court. The Supreme Court shall appoint an administrator of the courts and other assistants of the Supreme Court, as may be necessary to aid in the administration of the courts of this state. The administrator shall perform administrative duties assigned by the court. Section 4. Except to the extent limited or abrogated by Article 4, Section 6, or Article 5, Section 2, the Supreme Court shall have general superintendent control over all courts, power to issue, hear and determine prerogative and remedial writs, and appellate jurisdiction as provided by rules of the Supreme Court. The Supreme Court shall not have the power to remove a judge. Section 5. The Supreme Court shall by general rules establish, modify, amend, and simplify the practice and procedure in all courts of this state. The distinctions between law and equity proceedings shall, as far as practicable, be abolished. The office of master in chancery is prohibited. Section 6. Decisions of the Supreme Court, including all decisions on prerogative writs, shall be in writing and shall contain a concise statement of the facts and reasons for each decision, and reasons for each denial of leave to appeal. When a judge dissents in whole or in part, he shall give in writing the reasons for his dissent. Section 7. The Supreme Court may appoint, may remove, and shall have general supervision of its staff. It shall have control of the preparation of its budget recommendations and the expenditure of monies appropriated for any purpose pertaining to the operation of the court or the performance of activities of its staff, except that the salaries of the justices shall be established by law. All fees and perquisites collected by the court staff shall be turned over to the state treasury and credited to the general fund. Section 8. The Court of Appeals shall consist initially of 9 judges who shall be nominated and elected at nonpartisan elections from districts drawn on county lines, and, as nearly as possible, of equal population as provided by law. The Supreme Court may prescribe by rule that the Court of Appeals sit in divisions and for the terms of court and the times and places thereof. Each such division shall consist of not fewer than 3 judges. The number of judges comprising the Court of Appeals may be increased, and the districts from which they are selected may be changed by law. Section 9. Judges of the Court of Appeals shall hold office for a term of 6 years, and until their successors are elected and qualified. The terms of office for the judges in each district shall be arranged by law to provide that not all terms will expire at the same time. Section 10. The jurisdiction of the Court of Appeals shall be provided by law, and the practice and procedure therein shall be prescribed by rules of the Supreme Court. Section 11. The state shall be divided into judicial circuits along county lines, in each of which there shall be elected 1 or more circuit judges as prescribed by law. Sessions of the Circuit Court shall be held at least 4 times in each year in every county organized for judicial purposes. Each circuit judge shall hold court in the county or counties within the circuit in which he is elected, and in other circuits as may be provided by rules of the Supreme Court. The number of judges may be changed, and circuits may be created, altered, and discontinued by law, and the number of judges shall be changed, and circuits shall be created, altered, and discontinued on recommendation of the Supreme Court to reflect changes in judicial activity. No change in the number of judges, or alteration or discontinuance of a circuit shall have the effect of removing a judge from office during his term. Section 12. Circuit judges shall be nominated and elected at nonpartisan elections in the circuit in which they reside, and shall hold office for a term of 6 years, and until their successors are elected and qualified. In circuits having more than one circuit judge, their terms of office shall be arranged by law to provide that not all terms will expire at the same time. Section 13. The Circuit Court shall have original jurisdiction in all matters not prohibited by law, appellate jurisdiction from all inferior courts, and tribunals, except as otherwise provided by law, power to issue, hear, and determine prerogative and remedial writs, supervisory and general control over inferior courts and tribunals within their respective jurisdictions, in accordance with rules of the Supreme Court, and jurisdiction of other cases and matters as provided by rules of the Supreme Court. Section 14. The clerk of each county, organized for judicial purposes, or other officer performing the duties of such office, as provided in a county charter, shall be clerk of the circuit court for such county. The judges of the circuit court may fill a vacancy in an elective office of county clerk or prosecuting attorney within their respective jurisdictions. Section 15. In each county, organized for judicial purposes, there shall be a probate court. The legislature may create or alter probate court districts of more than one county, if approved in each effective county by a majority of the electors voting on the question. The legislature may provide for the combination of the office of probate judge with any judicial office of limited jurisdiction within a county with supplemental salary as provided by law. The jurisdiction, powers, and duties of the probate court and of the judges thereof shall be provided by law. They shall have original jurisdiction in all cases of juvenile delinquents and dependents except as otherwise provided by law.